Welcome. Today's topic is hours of work. For educational purposes only and not legal advice. Please do not copy. Hit subscribe. Your next review or video is coming up.
Title I Working Conditions and Rest Periods under Book 3 of the Labor Code of the Philippines. Art. 82. Coverage. The provisions of this title shall apply to employees in all establishments and undertakings whether for profit or not, but not to government employees, managerial employees, field personnel, members of the family of the employer who are dependent on him for support, domestic helpers, persons in the personal service of another, and workers who are paid by results as determined by the Secretary of Labor in appropriate regulations. As used herein, managerial employees refer to those whose primary duty consists of the management of the establishment in which they are employed or of a department or subdivision thereof, and to other officers or members of the managerial staff. What are the conditions to be a managerial employee under Book 3 of the Labor Code? Their primary duty consists of the management of the establishment in which they are employed or of a department or subdivision thereof. They customarily and regularly direct the work of 2 or more employees therein. They have the authority to hire or fire employees of lower rank, or their suggestions and recommendations as to hiring and firing and as to promotion or any other change of status of other employees, are given particular weight. Why are managers excluded from application of Book 3, Title I? Managers are excluded because their roles involve policy-making, supervision, and control. Authority over personnel actions, hiring, discipline, evaluation, etc. Flexible or irregular work hours. No fixed output tied to hourly labor. Their compensation is not based on time spent, but on the responsibility and results expected of their position. Who are the government employees excluded? Government employees, whether employed by the national government or any of its political subdivision, including those employed in GOCCs. The civil service embraces government-owned or controlled corporations with original charter and, therefore, by clear implication, the civil service does not include those GOCCs which are organized as subsidiaries of GOCCs under the General Corporation Law. Who are supervisorial employees? Those who effectively recommend managerial actions, e.g., hiring, discipline, transfer, but do not have final authority. They can only recommend actions subject to approval. Whereas the managerial employee are those who lay down and execute management policies or have the power to hire, fire, discipline, or make final decisions and has final decision-making power on management policies or personnel actions. Who are field personnel? Field personnel shall refer to non-agricultural employees who regularly perform their duties away from the principal place of business or branch office of the employer and whose actual hours of work in the field cannot be determined with reasonable certainty. Who are the workers paid by result? Workers paid by result are employees whose pay depends on the output they produce rather than the number of hours they work. Checkmark. They include piece rate workers, paid per unit produced, packyaw workers, paid per task or bulk of work, decay or quota-based workers. Commission-based workers, if tied to output, not hours. Article 83. Normal hours of work. The normal hours of work of any employee shall not exceed 8 hours a day. Health personnel in cities and municipalities with a population of at least 1 million, or in hospitals and clinics with a bed capacity of at least 100, shall hold regular office hours for 8 hours a day, for 5 days a week, exclusive of time for meals, except where the exigencies of the service require that such personnel work for 6 days or 48 hours, in which case, they shall be entitled to an additional compensation of at least 30% of their regular wage for work on the 6th day. For purposes of this article, health personnel shall include resident physicians, nurses, nutritionists, dietitians, pharmacists, social workers, laboratory technicians, paramedical technicians, psychologists, midwives, attendants, and all other hospital or clinic personnel. What are the exceptions to normal hours of work? The exceptions are the different types of flexible work arrangement. Compressed workweek is one where the normal workweek is reduced to less than 6 days but the total number of work hours is 48 hours per week. Reduction of workdays is one where the normal workdays per week are reduced but should not last for more than 6 months. Rotation of workers is one where the employees are rotated or alternately provided work within the workweek. Forced leave is one where the employees are required to go leave for several days or weeks utilizing their leave credits if there are any. Broken time schedule is when the work schedule is not continuous but the work hours within the day or week remain. flexi holidays schedule is where the employees agree to avail the holidays at some other days, provided there is no diminution or existing benefits as a result of such arrangement. What is the concept of flexible work arrangements? It refers to the alternative arrangements or schedules other than the traditional or standard work hours, work days, and work week. The DOL issued Department Advisory No. 2 Series of 2009 Guidelines on the adoption of flexible work arrangements. This is to assist and guide employers and employees in the implementation of various flexible work arrangements as one of the coping mechanisms and remedial measures in times of economic difficulties and national emergencies. Compensable hours worked. Article 84. Hours worked. Hours worked shall include a. all time during which an employee is required to be on duty or to be at a prescribed workplace, and b. all time during which an employee is suffered or permitted to work. Rest periods of short duration during working hours shall be counted as hours worked. Principles in determining hours worked. All hours are hours worked which the employee is required to give his employer, regardless of whether or not such hours are spent in productive labor or involve physical or mental exertion. An employee need not leave the premises of the workplace in order that his rest period shall not be counted, it being enough that he stops working, may rest completely and may leave his workplace, to go elsewhere, whether within or outside the premises of his workplace. If the work performed was necessary, or it benefited the employee cannot abandon his work at the end of his normal working hours because he had no replacement. All time spent for such work shall be considered as hours worked, if the work was with the knowledge of his employer or immediate supervisor. The time during which an employee is inactive by reason of interruptions in his work beyond his control shall be considered working time either if the imminence of the resumption of work requires the employee's presence at the place of work or if the interval is too brief to be utilized effectively and gainfully in the employee's own interest. The rules on waiting time spent by an employee. The following can be considered working time if waiting is an integral part of his work. The employee is required or engaged by the employer to wait. When is an employee considered working while on call? An employee is required to remain on call in the employer's premises or so close thereto that he cannot use the time effectively and gainfully for his own purpose. He is not working on call if he is not required to leave work at his home or with company officials where he may be reached. Attendance at lectures, meetings, and training programs. The following cannot be counted as working time if attendance is outside of the employee's regular working hours. Attendance is voluntary. The employee does not perform any productive work during such attendance. Rule on rest periods or coffee breaks. Rest periods running from 5 to 20 minutes shall be considered as compensable working time. Article 85. Meal periods. Subject to such regulations as the Secretary of Labor may prescribe, it shall be the duty of every employer to give his employees not less than 60 minutes time off for their regular meals. The rule on travel time. Travel time from home to work and work to home is not compensable. Travel from office to job site or from job site to job site is compensable. Travel away from home is compensable. The night shift differential. Article 86. Night shift differential. Every employee shall be paid a night shift differential of not less than 10% of his regular wage for each hour of work performed between 10 o'clock in the evening and 6 o'clock in the morning. Article 87. Overtime work. Work may be performed beyond 8 hours a day provided that the employee is paid for the overtime work, an additional compensation equivalent to his regular wage plus at least 25% thereof. Work performed beyond 8 hours on a holiday or rest day shall be paid an additional compensation equivalent to the rate of the first 8 hours on a holiday or rest day plus at least 30% thereof. Who are excluded from overtime pay? Government employees whether employed by the national government or any of its political subdivision, including those employed in GOCs. Managerial employees, officers or members of a managerial staff, domestic servants and persons in the personal service of another, workers who are paid by results, non-agricultural field personnel if they regularly perform their duties away from the principal or branch office or place of business of the employer and whose actual hours of work in the field cannot be determined with reasonable certainty. Undertime not offset by overtime. Article 88. Undertime not offset by overtime. Undertime work on any particular day shall not be offset by overtime work on any other day. Permission given to the employee to go on leave on some other day of the week shall not exempt the employer from paying the additional compensation required in this chapter. Emergency overtime work. The general rule is no employee may be made to work beyond 8 hours. However, there is an exception to this. Article 89. Emergency overtime work. Any employee may be required by the employer to perform overtime work in any of the following cases. A. When the country is at war or when any other national or local emergency has been declared by the National Assembly or the Chief Executive. B. When it is necessary to prevent loss of life or property or in case of imminent danger to public safety due to an actual or impending emergency in the locality caused by serious accidents, fire, flood, typhoon, earthquake, epidemic, or other disaster or calamity. C. When there is urgent work to be performed on machines, installations, or equipment, in order to avoid serious loss or damage to the employer or some other cause of similar nature. D. When the work is necessary to prevent loss or damage to perishable goods. And E. Where the completion or continuation of the work started before the 8th hour is necessary to prevent serious obstruction or prejudice to the business or operations of the employer. Any employee required to render overtime work under this article shall be paid the additional compensation required in this chapter. Computation of additional compensation. For purposes of computing overtime and other additional remuneration as required by this chapter, the regular wage of an employee shall include the cash wage only, without deduction on account of facilities provided by the employer.
Hit subscribe. Your next review or video is coming up.